new chapter that is on law, its nature and classification. Law is a very, very interesting and easy subject, honestly, to study about. What is law? Law is nothing but a system of rules that are created and enforced through social or governmental institutions to regulate behavior. Law as a system helps to regulate and ensure that communities show respect and equality amongst themselves. State enforced laws can be made by a collective legislature or by a single legislature, resulting in statutes by the executive through decrees, that is, court orders, and regulations are established by judges through precedent, normally in common law jurisdictions. Now, let's understand what is the meaning and definition of law. According to Roscoe Pound, law is the body of principles recognized or enforced by public and regular tribunals in the administration of justice. According to Austin, law is the aggregate of rules set by men as political superior or sovereign to men as political subject. In short, law is the command of sovereign. It imposes a duty, and duty is backed by a sanction. He further said that there exist three elements in law. First, command. Second, duty. And third, sanction. It is possible to describe law as a body of official rules and regulations generally found in the constitutions, legislations, judicial opinions, and the like, that is used to govern a society and to control the behavior of its members. So, law is a formal mechanism of social control. Legal systems are particular ways of establishing and maintaining social order. Now, what is nature of law? The word law is difficult to define, particularly as it is used in many different ways. It is concerned with behavior and not with causes, and either contains an element of inevitability, example, scientific laws, such as the laws of gravity, or of sanction, example, divine laws. It shapes politics, economics, and society in numerous ways and serves as a social mediator of relations between people. In the narrower concept of law, there must be a set of rules which can be applied objectively with someone to enforce them. There have been many attempts to put these into a workable definition. Some are more successful than others. According to Salmon, law consists of any principle which is recognized and enforced by the courts in the administration of justice. A body of rules for the guidance of human conduct which are imposed upon and enforced among the members of a given state. Now, what are the classification of law? Sir John Salmon refers to 8 types of law. They are as follows. First, imperative law. It means a rule of action imposed upon mere by some authority which enforces obedience to it. In other words, it is a command enforced by some superior power, either physically or in any other form of compulsion. Following are the 2 types of imperative law. First one, the divine law, which consists of command imposed by God upon men, either by threats of punishments or by hope of his blessings. The second imperative law is the human law, which is the law by analogy. The second type of law, as provided by Mr. Salman, is physical or scientific law. Physical laws are expressions of the uniformities of nature and general principles that express regularity and harmony, which are observable in the activities and operations of universe. They are not the creation of men and cannot be changed by them. Human laws changes from time to time and from country to country, but physical laws are invariable forever. The uniform actions of human beings, such as law of psychology, also falls into this class. They express not what men ought to do, but what they do. The third type of law is practical or technical law. It consists of principles and rules for the attainment of certain ends, such as laws of health, laws of architecture. These rules guide us to what we ought to do in order to attain certain ends. Within this category, there are the laws of music and laws of style. Next one, the fourth is natural or moral law. By nature or moral law is meant by the principles of natural right and wrong. That is the principle of natural justice. Natural law have been also called the following. First, the divine law, that is, commands of God imposed upon men. And the second one, law of reason, that is, being established by which the world is being governed. The third being unwritten law, as being written not on brazen tablets or on pillars of stone, but by the finger of nature in the heart of people. And the fourth one is the eternal law. It is being uncreated and invariable. And the fifth one is moral law. It is the expression of the principles of morality. The next type of law, that is the fifth one, is conventional law. It is a body of rules agreed upon and followed by the concerned parties to regulate their mutual conduct. It is a form of special law for the parties, which can be made valid or enforced through an agreement. A good example of conventional law is the laws of cricket or any other game, rules of club. It has been further divided into two groups, which are as follows. First, the rules enforced by the parties themselves, but not recognized by the state, like the rules of hockey. Second, the rules which are recognized and enforced by the state, like contract, etc. The sixth type of law is customary law. Customary laws are those rules of customs that are habitually followed by the majority of persons subject to them in the belief of binding nature. According to Salman, customary laws means any rule of action which is actually observed by men. When a custom is firmly established, it is enforced by the authority of the state. Custom is not law itself, but an important source of law. Only those customs acquired the force of law which are recognized by the courts. The seventh one is the international law. According to Hughes, international law is a body of principles and rules which civilized states consider as binding upon them in their mutual relations. It can be defined as the name of the body of customary and conventional rules which are considered legally binding by civilized states in their intercourse with each other. According to Salmon, it consists of those rules which the sovereign states have agreed to observe in their dealings with one another. International agreements are of two types. They are either expressed or implied. Expressed agreements are contained in treaties and conventions, while the implied agreements are to be found in the customs or practice of the state. International laws are divided into two types. First, public international law, that is, it prevails universally in all over the world, and private international law. It is enforced only between some of the states. Over here, states would mean the countries. The last one, eighth law, that is civil law. It is a law of the states regarding the land, the law of that particular nation. Civil law, according to Salmon, is the law of the state or the law of the land, the law of lawyers, and the law of courts. It is the positive law of the land, which means the law as it exists. It is backed by the force of might of the state for purpose of enforcement. Civil law differs from special law as the sitter applies only in special circumstances. The other term used for civil law is municipal law and national law. Now, let's discuss an important aspect of this lesson, that is sources of law. The next source of law is equity. The word equity has a meaning of fairness. Equity developed because of problems in common law. Major problem was the fact that the only remedy the common law courts could give was damages, which is an order that defendant pay a sum of money to the plaintiff by way of compensation. In some cases, this would not be the best method of putting matters right between the parties. Example, in a case of trespass to land, where perhaps the defendant had built on his neighbor's land, the building would still be there and the plaintiff would have lost the use of that part of his land. In such a situation, the plaintiff would probably prefer to have the building removed rather than be given money in the compensation. The third source of law is the case law. In the English common law system, case law develops as courts hear disagreement between parties, making a decision as to what the law should be in a particular case. These decisions create precedents. The doctrine of judicial precedents operates by ensuring that a previous court's decision is followed by another court when deciding a subsequent legal case, provided certain rules for extracting the legal principle from the earlier case, and that principle applies to the case which are to be followed by that case. The next source of law, the fourth one, is statute law. Statute law comprises of legislation that are made by the House of Parliament. Legislation may be a primary legislation which starts as a bill and becomes an act of the Parliament, or it may be secondary or delegated legislation drafted by the government department and enacted under powers given by primary piece of legislation. The legal system defines a set of rules, conducts, and procedures which are necessary for establishing and maintaining a disciplined society. It has been formulated by custom, agreement, and national interest, and is enforced through a set of institutions. The Indian legal system is one of the oldest and longest written set of laws in the world, Our legal system has its roots in the legislature formulated during the British Raj era. The Indian legal system is formulated barring in the mind the diversity of the country and with due respect to the religion, customs, and traditions of the people. What do you understand by jurisprudence? Jurisprudence is the study of law. It is a type of science that explores the creation, application, and enforcement of law. Jurisprudence is the study of theories and philosophies regarding law. The word jurisprudence is derived from the Latin phrase jurisprudential. This means knowledge of law. What's the definitions of jurisprudence? In the words of Austin, jurisprudence is concerned with positive law. According to Salmon, jurisprudence is the science of law. Here, law stands for law of land or civil law. Chetan considered jurisprudence as the study and systematic arrangement of the general principles of law. Roscoe Pound described it as jurisprudence as the science of law. Explain about the Law Commission of India. Law in a society should be dynamic, not as a static object, as in black letter law. Society continue in changing nature so as the law of the society. The first such commission was established in 1834 under the Charter Act of 1833 under the chairmanship of Lord Macaulay, which recommended codification of the Penal Code, the Criminal Procedure Code, and few other matters. The Government of India reacted favorably and established the first Law Commission of Independent India in 1955 with the Attorney General of India, Mr. MHCET as its chairman. Since then, 21 more law commissions have been appointed, each with a 3-year term and with different terms of reference. Law Commission and its chairman have been like Second Law Commission was from 1958 to 61 and the chairman was Mr. Justice T.V. Venkatramana Iyer. The Third Law Commission was from 1961 to 1964 and the chairman was Mr. Justice J.L. Kapoor. The Fourth Law Commission from 1964 to 68 was chaired by Mr. Justice J.L. Kapoor. The Fifth Law Commission, which was from 1968 to 71, was chaired by Mr. K.V.K. Sundaram, ICS. The Sixth Law Commission was from 1971 to 1974 and the chairman was Mr. Justice Dr. P.B. Gajendra Gadkar. The Seventh Law Commission was from 1974 to 1977 and Mr. Justice Dr. P.B. Gajendra Gadkar was also chairman at that time. The Eighth Law Commission, which was from 1977 to 1979, Mr. Justice H.R. Khanna was the chairman. The Ninth Law Commission, 1979 to 1980, Mr. Justice P.V. Dixit was the chairman. The 10th Law Commission, 1981 to 1985, the chairman was Justice K.K. Mathew. The 11th Law Commission was from 1985 to 1988, where Justice D.A. Desai was the chairperson. The 12th Law Commission was from 1988 to 91, and the chairperson was Justice M.P. Thakkar. The 13th Law Commission from 1991 to 94 The chairperson was Justice K.N. Singh. The 14th Law Commission from 1995 to 1997. The chairperson was Justice K. Jayachandra Reddy. In the 15th Law Commission, which was from 1997 to 2000, the chairperson was Justice B.P. Jeevan Reddy. The 16th Law Commission was from 2000 to 2001, where the chairperson was Justice B.P. Jeevan Reddy. He continued from the previous commission. And in 2002-2003, we had Justice M. Jagannatha Rao as the chairperson. In 17th Law Commission, 2003 to 2006, Justice M. Jagannatha Rao continued as the chairperson. And in 18th Law Commission, 2006 to 2009, Justice A. R. Lakshmanan was the chairperson. In 19th Law Commission, from 2009 to 2012, Justice P. V. Reddy was the chairperson. In 20th Law Commission, which is from 2012 to 2015, we had chairperson as Justice D. K. Jain. The 21st Law Commission, which is from 2015 to 2018, we had Justice Balbir Singh Chauhan as the chairman. Now, what do you understand by review or repeal of obsolete laws? First, to identify laws which are no longer needed or relevant and can be immediately repealed. They are not required. The second one, to identify laws which are in harmony with the existing climate of economic liberalization, which need no change. The third one, to identify laws which require changes or amendments and to make suggestions for their amendment. The next one, to consider in a wider perspective the suggestions for revision or amendment given by expert groups in various ministries or departments with a view to coordinating and harmonizing them. The next one, to consider references made to it by ministries or departments in respect of legislation having bearing on the working of more than one ministry or department. And the last one, to suggest suitable measures for quick redressal of citizens' grievances in the field of law.